After an injury occurs, plaintiffs must take reasonable steps to prevent their losses from getting worse, such as promptly seeking medical treatment and following medical advice. In Hutchins v. Schwartz, we'll explore whether this duty to mitigate may begin even before the injury occurs. Charles Hutchins's vehicle collided with Robert Schwartz's vehicle. As a result of the accident, Hutchins, who wasn't wearing his seatbelt, immediately suffered some cuts, bruises, and a broken toe. Hutchins allegedly later experienced back injuries, a hiatal hernia, lost enjoyment of life, and lost earnings. Hutchins sued Schwartz for $275,000 in compensatory damages for Schwartz's negligence in an Alaska state trial court. Denying Hutchins's motion in limine, the judge admitted evidence that Hutchins didn't wear his seatbelt. Hutchins moved for a directed verdict on the seatbelt issue, arguing that his seatbelt wasn't operational and that his non-use didn't impact his particular injuries. Granting the motion, the judge instructed the jury to disregard the evidence. The jury found Hutchins 40% responsible and Schwartz 60% responsible for the accident, but only awarded Hutchins $1,900 in damages. Hutchins moved for a judgment notwithstanding the verdict or a new trial, which were denied. Although the jury found Schwartz more negligent than Hutchins, when the court entered judgment, it found that Schwartz was the prevailing party and awarded him $17,000 in attorney's fees. Hutchins appealed to the Alaska Supreme Court, arguing that the court erred when it initially allowed the jury to hear evidence that he hadn't used his seatbelt. Schwartz cross-appealed, arguing that the trial court shouldn't have directed the jury to disregard the seatbelt evidence, but that such direction cured Hutchins's concerns.